I've heard of that one.
Call. I don't know. This is my first one. Well,
So she didn't see any notice in the mail.
You know, it's been 4 years since I saw her about, and we've never been related because we hadn't seen each other since the old days. We knew where we were going to be yesterday. We were both in the same hotel.
I was back. How you got here? She's older one. She was married, had kids long before Carlene was out of high school. She's got kids 40 years old. Yeah. A couple years older than Carlene, 3 years older. Yeah. Yeah, it's meant for the Ashland. They have a big airport. I mean, yeah.
And I've been serving as the lead attorney on this case since we filed it in early 1986. And I'll try and give you just kind of a little background on the case itself, and then talk where we're at right now in terms of the settlement discussions with the federal defendants, with the Bureau of Indian Affairs, and as well as Indian Health Service, because they're a named defendant in the case too. We filed the case in 1986, and at the time that we filed it, we weren't all that sure as to whether we were going to be successful, because there were some problems with the statute of limitations. That means that we thought we might have been too late in filing the lawsuit within a number of years. But in the course of pretrial proceedings, some early motions in the district court, we were successful before this one judge that was handling the case, still is assigned to the case, Judge Schwartz, who wrote the So we overcame that initial obstacle. The government decided at that point that they would negotiate with us rather than fight us in court, which I think was a wise decision. So we've been involved in negotiations for about 2 years, serious negotiations. And we're very close at this point to reaching a final settlement. What I'd like to do is talk about that, but also talk about another aspect of the case that involves the city of Chico. When we initially filed the lawsuit, we sued the city of Chico, we sued Butte County, we sued Mendocino County, we sued Sonoma County, who else did we, and Lake County. The reason that we sued those counties is because the different tribes were located originally in those counties, and we didn't know how much land still remained in Indian ownership, and there might have been a substantial claim for back taxes against the counties for those lands that remained in Indian ownership. After we filed the lawsuit, we did some discovery, what they refer to in legalese as discovery. That means basically finding out more facts about your case. And we realized that those claims against the county and the city defendants were pretty small in actual dollar amounts, and that it made more sense probably to just dismiss those claims and avoid the hassle of dealing with the cities and the counties in the settlement process. Because we were going to deal with the federal defendants, with the United States government, and the cities and counties were starting to make all these noises about, we don't want this case to settle because this means that we're going to have lots of Indian people attempting to acquire lands within our jurisdiction, and it's going to create jurisdictional problems, and we've heard all about these bingo halls and different kinds of operations that are going to occur. We don't want that in our communities. Well, that's not, I'm oversimplifying. But those were some of the sentiments or concerns that were expressed, and some of them were legitimate concerns. Some were, I think, concerns based on a lack of real understanding of the status of Indian tribes and a lack of an understanding of the historical backdrop of termination and the serious and pretty tragic effects of termination on Indian people. So what we did is we made a motion in the district court to dismiss out the city and the county defendants, that is to just drop them from the case. And the judge, I think, thought it was a good idea as well, simplified the case. And we had a good, strong argument for dropping them. We didn't feel that they had any interest that was a protectable interest. Well, the judge dismissed them. Mendocino County, Sonoma County, Butte County, Lake County, none of the counties appealed that decision to a higher court. The city of Chico did. They appealed the decision saying that they were entitled to intervene in the case, and they argued to the appellate court that they had a serious concern because there's still land held in Indian ownership, actually 2 parcels, in the area of downtown Chico. One is a parcel that's a cemetery, which I don't think the Indian people are going to be building on that particular parcel of land. And the other parcel of land is held in individual ownership by one of the original distributees of the Chico Rancheria. They were also concerned, the city of Chico was also concerned that if the tribe was unterminated, that they would acquire land within the city's, not even necessarily within the city limits, but within their sphere of influence or their zone of influence, and that might create a jurisdictional problem because if those lands are held in trust status, trust means that title to Indian lands is generally held by the United States in trust for the tribe or for individual Indians. And the state and the county does not have general civil jurisdiction on those lands. they would have criminal jurisdiction because California is a public law 280 state, but they wouldn't have civil jurisdiction. That means they couldn't, generally, they could not zone, they could not regulate businesses on that land, etc. So the city had these concerns. Now, from a governmental standpoint, those are legitimate concerns, but the problem is the city of Chico never really sat down and talked directly with the Indian people. I mean, we, to some extent, we didn't want to talk with them at that time because they were taking a pretty hard line. The reason I mention this background is because we argued that case in the Ninth Circuit Court of Appeals about 3 weeks ago. And the Ninth Circuit issued an order about 4 days ago in that case. What they did is they directed the parties, that means the United States and the tribes involved in this case, to sit down with the city of Chico and see if there's any basis for reaching some kind of agreement, or at least talking about the issues. My concern about that is that it might slow down the settlement process, but I don't think it, I personally don't think it has to. And ultimately, the rancheria, the tribe, is going to have to at some point talk with the city of Chico about some of these issues, particularly if there's going to be any land acquisition in that area around there. The city has made some very unclear statements about providing housing assistance to Indian people, and as a trade-off to some agreement not to develop or to take any of the lands that are now in Indian ownership from Chico back into trust status. So there may be, I don't know, there may be some basis for talking with the city of Chico. There may be some incentives for things that they would be able to offer as a city to the Chico people that would be of some benefit. I don't know. There's nothing on the table at all. But I wanted to raise that. We're probably going to be involved to some extent in some discussions with the city of Chico in the next month. Okay, that's what I'd like to do now is to talk about where we're at with the federal government. I said that we're very close to a settlement. If we settle this case tomorrow, what does that do with reference to the city of Chico? Well, if we settle this case tomorrow with the United States, we would advise the Court of Appeals that we've settled the case, and I suspect that they would find that the city of Chico's concerns are moot, meaning that the case has been settled, so there's nothing else that the court can do. So the point I'm trying to make is I'm concerned somewhat about the city of Chico, but it's not a major concern at this point. My main concern on behalf of the tribes is to settle the case with the United States and then deal with whatever the city of Chico has to say later at some point. The major obstacle right now is just getting the settlement. Let me outline what's actually in the settlement as it appears today, and I'll also talk about a meeting that we had I think it was early February, I think, with the area director of the Bureau of Indian Affairs and some of his staff. Basically, under the settlement, what would happen is that the United States would recognize or acknowledge that the Chico Rancheria and the other rancherias involved in this case, the tribes involved, were unlawfully terminated. And they would issue a proclamation that would be published in the Federal Register and local newspapers, rescinding or taking back the termination of those people. That means that as individuals, you would be restored to your status under federal law. Now, some of you who are dependents, who were considered dependent members when the rancheria was terminated have already been unterminated. And some of you may not know that, but in 1976, we, CILS, litigated one case called Knight versus Cleffy, which basically said that the government did not follow the correct procedures in terminating the status of dependent members. That means people in this room that were children of distributees, spouses of distributees, were not properly terminated. That meant that you were entitled to your Indian status that you had before termination. You were eligible for educational benefits, you were eligible for housing benefits, you were eligible for health benefits. Now, we have found out that the government, despite the existence of that court order in 1976, has not complied with it. I would venture to guess, probably even guess, that there are people in this room that have been denied education benefits because the BIA has said that you're a terminated Indian. And we'd like to know when that has happened and who it's happened to, because we're trying to correct that. Finding out that that's happened with a number of rancherias, in fact, all of the 4 rancherias involved in this case. But what this case would mean is it would mean that not only would dependent member status be reaffirmed again, but the distributees would be unterminated too. Those are the people that received lands under the original termination of rancheria, that they would be restored as well. Now, the government has agreed that they would also restore, that's individual Indian status. That means that as individuals, you could apply for higher education benefits. If there were other programs available, like health benefits, individual type benefits, you would be eligible for them. But what's more important is they agreed that they would restore the tribal identity of these 4 groups, so that you would ultimately be listed on a list that's published usually once a year in the Federal Register that identifies all of the tribes in the United States that have a government-to-government relationship with the United States. And that's a very important status for you, because that's the status that enables you to participate in federal programs such as land acquisition, the HUD land acquisition program, the HUD housing programs, other economic development programs sponsored both by the Bureau of Indian Affairs, and there's some other programs that are sponsored or administered by other federal agencies. The aspect of that that is unclear is the government has not been willing to say that the 4 groups involved here, 4 tribes, Chico, Eagle, Scotts Valley, are historical tribes. That is similar to, say, a tribe like let's take one of the biggest tribes, the Navajos. One of the problems is that in California, a lot of Indian people were dispersed because during the late 1800s, mid to late 1800s, were either almost wiped out or dispersed or pushed off their lands by settlers. And a lot of tribal groups and bands were broken up. Tribal structures were purposefully destroyed with the active involvement of the federal government as well. So that when they began to acquire lands in the early 1900s, like 1915, 1916, for Indian people, they acquired these lands for, quotes, homeless California Indians. There were a lot of groups of Indian people in California that had survived, had maintained at least some community identity. Some of them had maintained very strong community identities. They put these groups on a land base. And so the government is saying, well, we're not really willing to say that these groups are like the Navajo Nation or the Sioux Nation. Well, what we decided is rather than get into a hassle on that point right away, is if they're willing to unterminate the four groups and list them as federally recognized groups that have under a constitution that they've adopted, that we can worry about what powers you have at some later point in time. But basically, like the Chico Rancheria is an IRA rancheria, or an IRA tribe. So you have adopted a constitution under the Indian Reorganization Act. That act delegates very broad powers to tribes. Tax, you have the inherent power to determine your own membership, to regulate activities within your lands. We'll talk about the land base later. But basically, you would be in a position to function as a government if you wanted to pursue that particular course. I know Carlene mentioned at one of the meetings we had, or after one of the meetings with the Bureau of Indian Affairs, that that's a lot of responsibility. And that means that if you function as the government, you have to have some kind of system in place, some kind of laws or traditions that people follow. And it is. It's a considerable responsibility. But it's not anything that you're not capable of. Because we've worked with lots of Indian groups that have been unterminated. And Darlene will talk about some of that later. And it's amazing what has occurred with some of these groups in a very short period of time. The kinds of things that they're doing, the kinds of negotiations that they've been involved in with cities and counties and states and the federal government on a government-to-government basis. So your tribal status, your individual Indian status would be restored. Also, the federal defendants have agreed, and this is the thing that bothers the city of Chico the most, that, well, I should mention, unlike other rancheria cases, in this particular case, we did not include in our settlement demands restoration of the original Chico Rancheria boundaries. We did that for two reasons. One is there was so little land left within the original Chico Rancheria. It would have created a major jurisdictional problem. We had two small parcels of land that were in Indian ownership, and if those lands were placed back in trust, which would be at the option of the tribe as to the cemetery and as to the individual Indian landowner as far as the other parcel, you would have this checkerboard jurisdiction with the city having some kind of jurisdiction, possibly in some areas, the tribe having jurisdiction in other areas, even the potential for the tribe to have jurisdiction over non-Indian lands within the original boundary. It was even the problem or the situation was even a little different with, say, regards to Lytton. There was no land that was still in Indian ownership. There's no land within the former boundaries of Lytton. There are two parcels on the West Valley, and on Geedieville, they have the largest amount of land, about 6 parcels. Most of the groups, well, all of the groups, we discussed this, and all 4 of the tribes decided that it was more important for them to get money to acquire lands elsewhere where the lands would be a consolidated land base. It would be all Indian land. It wouldn't be this parcel is Indian, this parcel is not Indian, this parcel is Indian, and we have jurisdiction here, and the state has jurisdiction here. It would eliminate those problems. It also made the government more receptive to the settlement because we weren't restoring the original boundaries. But what we did insist is that if Indian lands remaining within the original boundaries of any of these 4 rancherias, that the government would allow those lands to be taken back into trust status. And that's what's in the settlement agreement right now. Also, they agreed to clear liens and taxes that may have been assessed against those lands that are now still an encumbrance against those lands. For example, if an Indian person had not been able to pay their taxes and the land was subject to a tax sale right now, the government agreed to clear the tax liens against those lands. Now, I'm talking about, as I mentioned, very few parcels of land involved. The second thing that they agreed is that if there were any lands that the Indians acquired later within those original boundaries, that they would take those lands into trust. For example, if, and I don't think this will happen, but it might, who knows. Let's say the Chico tribe, or the Chicta tribe, acquired 20 acres within the old Chico Rancheria. I think that's all residential. But let's assume that happened. Under the agreement, they could request the United States to take that land into trust. I can guarantee you the city of Chico would have all kinds of fits about that. They probably couldn't stop it. The third thing that they agreed is that they would support land acquisition by the 4 tribes. And that's probably one of the most important aspects, is that once you're unterminated, you can begin to access federal programs to acquire other kinds of lands. And that's really what has been the most significant aspect of the settlement of the other untermination cases, is that these small tribes, like Robinson, have been able to identify lands that are available that they can acquire and build homes on, build a tribal center on. It's a beautiful center here. And also develop some kind of business. Bingo hall, as far as Robinson is concerned here. Other tribes have other kinds of establishments. We probably could have closed this, we probably could have settled this case a year ago. But one of the things that was lacking was, okay, that's great, you're going to unterminate these people. We're going to dismiss our damages claims. We're going to waive attorney's fees in this case. How are these people possibly going to gear up and to even get through the process of making grant applications? How are they going to do this without some kind of government support? So we started talking about money, which has been a critical issue in all of the untermination cases. And what's come out of that basically is an agreement, and this is being discussed in Washington, D.C. right now, trying to reach some final agreement on it. Let me read this is what was agreed to at the meeting that we had in February with the area director. It's probably better I can read it to you and then we can talk about it. It says the federal defendants, it's the BIA, Indian Health Service, will immediately undertake to prepare a comprehensive needs assessment for each of the 4 rancherias, including the projected needs of the rancherias for federal programs and services through fiscal year 1994. That's 3.5 years down the road. These needs assessments, needs assessment is basically going out and finding out what is the composition of your community. How many elderly people do you have? How many people of school age? How many young adults? How many small children? What are their educational needs? What are their housing needs? What kind of a land base would you need? These needs assessments shall provide an initial basis for the BIA to request new tribes money for the 4 plaintiffs' tribes commencing in fiscal year 1992. say new tribes money, this means a special appropriation set aside for the unterminated tribes, the 4 tribes involved here. We may pull in another 1 or 2 tribes. But these would be tribes that would have a special appropriation. They would not be competing against all of the other California tribes for that money. That's the real value of a special appropriation. The Assistant Secretary, Indian Affairs, will request and support the addition to the fiscal year 1992 budget request and appropriation of new tribes money based on the needs assessments prepared for the 4 rancherias. In subsequent or later fiscal years, extending through 1994, the Assistant Secretary shall request and support such further amounts as are consistent with his initial request and with more current estimates of the actual needs of the 4 rancherias. It is understood that the availability of these funds is subject to funds being appropriated by Congress. Well, the deadline for getting in a request for new tribes money is probably the end of this month or May. I think Jager said that we could probably extend it through May. So the initial needs assessment is going to be a pretty bare bones one. But what we're trying to write into this is that we'll do an initial needs assessment, we'll get the request into Congress, we'll lobby for that money, and in the meantime, we'll do a more comprehensive needs assessment or assessment of the needs of your people. That will then amend our application and try and plug that in to get adequate funds. The main thing is to get an amount of funds that are going to be adequate to meet their needs. In fiscal year 1990, that's this year, the BIA Central California Agency will provide each of the 4 tribes with a grant of at least $4,000 from that agency's Aid to Tribal Government funds to assist the tribes in their initial self-governing efforts. In fiscal year 1991, that's next year, each of the 4 tribes will be entitled to a share of such funds, these are the Aid to Tribal Government funds, equal to that received by other federally recognized tribes serviced by the Central California Agency. What this means is that at least for this year, most of the monies to Central California Agency have already been allocated, but they're going to set aside an amount to at least enable you to get some initial things going for your people, some kind of a budget to work with. 4,000 is a minimum. There may be a little more money per tribe than that. It depends on how much of the money is. Some tribes, even though they're eligible for this money, there are some tribes that don't apply for it. So sometimes they have some extra funds left over. We want to get an application in for those monies as soon as possible. I'll be talking with Ron Jager next week about can we apply right now, even though we haven't signed the final agreement when we get the process. They are called Aid to Tribal Government. The federal defendants will also provide funding for workshops to be conducted by a technical team comprised of representatives, the BIA, Indian Health Service, Department of Housing and Urban Development, and such other consultants as may be necessary for the purpose of providing needed technical assistance to the 4 tribes. Scheduling and the content of the workshops will be developed by the federal defendants in consultation with representatives from each of the 4 tribes and will be designed to provide, at a minimum, specific information regarding federal programs available to Indian tribes, including the tribal contracting requirements of Public Law 93-638. That's the main funding vehicle for tribes. An overview of those Indian programs available to meet the development needs of individual Indians, such as healthcare, educational, and vocational training. The funding provided by the federal defendants for these workshops shall also include an amount sufficient to cover the costs of attendance at the workshops of at least 1 representative from each of the 4 tribes. We're going to try and get more than funding for more than 1 representative. Basically, we we need some workshops for tribal representatives to just bring them up to speed on federal programs, and let them know what's out there. At this point, I had a discussion with the attorney that's handling this case for the United States 2 days ago or 3 days ago. He's supposed to get back to me next week with a response from the Bureau of Indian Affairs Washington, D.C. office, which is handling this case. This case is being handled out of Washington, D.C., not out of California. It's being coordinated in California. So at this point, we're very close to settlement with the government. And the process of settlement will be, once we get a final agreement, every member of the 4 groups will be sent a notice advising them of the terms of the settlement. If people want to object to the settlement, they can object to the settlement if they wish. You don't have to object to it. I think it's in fact, if we reach settlement on these terms, I think it's a fair settlement, it's a good settlement. But everyone will be given notice, so it's all out there on the table for people to look at. There'll be a period of time during which people can register their comments on the settlement. And then there'll be a final hearing before the federal district court, and the judge will determine whether the settlement is fair and adequately represents or adequately protects the interests of all of the class members. Class members being the members from each of the 4 tribes. At that point, we will enter a final judgment, and the case will be essentially over at that point. And assuming that we get all the things that are in this settlement right here, the work will just be beginning in many ways for the Indian people of Rancherias in terms of land acquisition. But that doesn't mean that CRS just disappears. We've done a lot of work with tribes that have been unterminated on land acquisition, on various kinds of problems that you're going to confront and you're going to deal with well subsequent terminations. Well, my mouth is kind of dry because I've been doing all the time. I hope that that's somewhat clear. It's an overview of about 4 years. And if you have any questions, please don't hesitate to ask questions.
Well, you said that no city can say of chief or at a county, but what about the state Presbyterian Church? Because there are overseers at one time, and the state gets some of probably any individual lefties.
What are their concerns?
They won't have no concern over that. If we put a suit against them or something like that for trying to see if we get the land any individual lefties.
Well, the land, what you mean the land was, that's the original Rancheria.
No, this was an any individual that was entrusted to the church, and they somehow gave it to the chief of state college. And they've got some of the land that he left. But the other part was the Rancheria part, but this is something else.
I don't know.
That one parcel there, her nephew took back away years ago. He took that back, himself, that parcel that was left on the other side. Her nephew.
Is that before termination? I don't know the background of that. Something we can.
That was her
look at.
only
I mean,
surviving
that's-
nephew, and he farmed that land back.
Could he do that legally?
Can he do it legally?
She
far as
left
I
the will,
know.
she left the will to the Indians in the chief of state.
I don't know. I mean,
He was the only surviving nephew.
yeah, I can't tell you what.
There was no, he never had no, like,
First time.
nothing really saying that she left it to him.
We've been dealing with just the parcel of land.
Jesse, don't you listen about that?
No, not about the parcel. I was wondering, in the settlement, is there anything relinquishing our right
settlement will be with the federal government, and it will challenge, their unlawful termination of the
That's
rancher.
all, it's not, it's
Maybe.
concerning termination.
Yeah, what's happened with a lot of, what happened at the end of termination, some of the Chico Rancheria was sold to the Chico State.
Yeah, the city, Chico.
Yeah.
Just at 14 acres.
Right, but there was some, I suspect, I don't know, I have the documents on that, but that was done after termination.
Yeah, so the termination was
But it
unlawful.
wasn't.
Taxation was unlawful.
And some of that property down towards the creek down there, that some of the dormitories had, the big football field is on, was condemned and taken over by the state.
The BIA, they took the
And
money,
there was
they
no-
sold it and didn't give,
No
under
monetary
termination,
or nothing.
under termination, the money was supposed to go back to the tribe and the money didn't go back to the tribe.
Chico State,
Well,
Chico State Gymnasium, Actor Gym, is standing right on Indian property from Sacramento Avenue to the creek, to Little Chico Creek. There was supposed to be a 99-year lease on that property. We've never been able to determine what happened to the lease, or whether the state absorbed it in taxes or what. And the property from Warner Street up to the high school was supposed to be given to us by Mrs. Bibble also. We've never been able to determine what happened to that. And that's what
I
we're
haven't seen
concerned
any,
about now.
I haven't seen any documents on that at all. I don't, my understanding was that, that part of the land was sold at the time of termination to, Chico State.
That's 14 acres on Sacramento Avenue.
That was 2,100 approximates. That is on south side of Sacramento.
14 that was sold to the city.
14 was sold at termination time, but I'm talking about a 99-year lease that was supposed to have been given to the college that we don't know nothing about. We haven't been able to dig up any kind of information about it because Reverend Tilbury had died off.
On the 14 acres,
It runs right into the 14 acres because the college athletic field of it.
what I'm trying to get at is, there were 14 acres that were sold to the city of, to,
State of California.
Chico State.
Yeah.
Okay, all right. Were those lands then leased, is that what you're saying?
No,
No.
there's a difference.
Another parcel.
It's another parcel from the 14 acres to the creek.
Is that over there by that
South.
soccer field?
That's where I have the
Soccer
dormitory,
field,
yeah.
That is-
There, I could
that-
never
that
find
land-
anything.
That land was condemned and given to the state of
Yeah,
California.
because when we went through the records, I could find
Yeah,
out
it was condemned.
nothing on where it was sold.
Because nobody,
Well,
nobody,
yeah,
The termination was illegal, wouldn't that also make the condemnation of that land illegal?
no.
There's nothing on the land.
Yes, you can do anything you want to.
State of
Yeah, but I
California,
mean,
condemn your house and tear it down.
If we were terminated illegally in the first place,
I just want to know, to that question, does it relinquish our right to go after, legal means to go after that? Because I know that some rancherias, to get other lands and stuff, they say, we'll just let them go, the other part, traditional land.
Well, you're not, what you're doing is you're relinquishing any claims that you have against the federal government relative to termination. What the
so it
claims,
has no effect on the
What-
state.
what it means is that as to the federal defendants in this case, the Bureau of Indian Affairs, that when the agreement is signed and provisions of the agreement are met, that's the end of any claims that you have against the United States. Whether you have other claims against other entities, they
So
would,
if we were.
like if there was a claim against Chico State or other parties, they're not parties to this case. So that wouldn't foreclose any claims against them. It wouldn't foreclose any claims against the city or
Would it
the county.
strengthen a case to go after the state on taxation reasons for losing the land?
I'm not sure whether, you mean right now? To go
I mean,
the
after
state?
everything's said and done, I'm going to go back.
You'd have to take a look at the case, really. You have to look at the facts. You have to look at how the lands were lost. What happened in a lot of these cases is that when the rancherias were some of them sold their land mostly to other people, non-Indians. Those non-Indians thought that they were getting good deeds. They weren't, in most cases, they weren't attempting to defraud the Indians. There were situations like at Hoffman where there was some fraud involved in how the lands were acquired by non-Indians. But in a lot of situations, they bought the land like it was they were getting a deed. So you have situations where people may have settled on those lands and built homes. And you would have to, if you wanted to make a claim to those lands, you would have to sue all those people and prove up that not only was termination unlawful, but that you're entitled to overturn their title to that land. And that's a real tough case to win. Now, I don't know the background of the sale, this other lease that you're talking about of 20 acres. You're talking about acreage that was outside of the original Chico Rancheria? Yeah. But why if it was outside the Rancheria, how did the Indians have a claim to that land?
It was divided by Sacramento Avenue.
Yeah, an individual, when she passed away in 1918, she left a will to the land for the Indians here. And Presbyterian Church are overseers, and as I told you, they're overseers, they're a non-profit. Do we have to pay taxes on that land that we lost beside a regular church?
I just can't answer your question. I have to go back and see if there's some documents.
Would you be willing to take a quotation from a California Historical Society document, which gives a very one-sentence history of that situation? We happen to have that here, not by design, but there is a reference to that. This is Goodwill, incidentally, I was going to ask you, to what year would historical tribe, like you say, the Navajo, the small group of Indians and Chico Creek, the documents reflect that.
I would like to get copies of that. Yeah, when I say that they were not willing right at this point to say that the Chuka tribe is not a historic, they weren't willing to say that the Chuka tribe is a historical tribe or that Ediville is historical. It's not to say that you're not a historical tribe. What I'm trying to point out is that the government is making this argument with a lot of California rancherias, and I think it's a bogus argument because they participated in the process of destroying and dispersing the Indians. And now they're saying that, well, these bands can't show that their roots go back 100 years. And I think that most of them can, but the proof is in different places. You have to get an anthropologist to go and actually look at the threads. Well, that's okay. I mean, I can, as I understand, I just want to be clear that you have the 14 acres that were sold to Chico State University at the time of termination. That money supposedly was set into a trust account for the Chico people. I mean, I can follow up on that. Okay. Second thing is, what I hear people saying is that they thought that there was 20 acres adjacent to the rancheria, next to the rancheria, below Sacramento Avenue, is that what? Okay. That was, they thought was supposed to be Indian land, but is now under a lease.
It's from Sacramento Avenue to the Little Chico Creek on the east side, Warner Street. And it was supposed to be under a 99-year lease, but we haven't been able to dig anything up on that.
99-year lease to
The college. Archer. That area was always.
That was what was actually charged by the Presbyterian Church.
Yeah, whoever built it.
Have you looked at the, documents that the Presbyterian Church has?
No.
Is it possible to see their archives like that?
I don't know,
Well,
we
see-
haven't, when we brought this lawsuit, we didn't sue the Presbyterian Church. All we were trying to do was to unterminate the 40-acre parcel. So we weren't dealing with adjacent land. They're good questions,
But it's
to me, it's just some new information.
Too, but I just found it hard to get information from the Presbyterian Church. That's why I asked you.
Yeah, we can certainly,
I'm sure you
we
can.
can make that kind of request.
Well, it still wouldn't have less to do with people in the county or anything, it would keep us from getting our rights back.
Well,
Well-
all we have to do is just wait until we get this business settled and then move on to the next business.
Yeah, well,
Yeah, I-
we should.
Like on that one document that I went to the Indians, he knew that. But if it belonged to the Indians, then either he was gonna try to get, either he was gonna take it, one way or another. He was gonna go to the city to get that land. And I'm not sure if it was, 14 acres. It's, the city developer at that time, this is back in, back in 1945 or 1941. Is he realized that the paper is all that way, and I was reading through that. But it did say that, the city engineer, he was going to find out about the land that the Indians had. And there's another document on whether the city was going to put sewer lines through, because that was the way they had to go, was through the rancheria. In order for them to go through there, DIA had told them that they would have to give sewer lines, sewer service to the Indians free of charge. But my job is asking my
That's one of the bases for terminating a lot of the rancherias, is that they were promised water and sewer facilities, but they never got them. And that was one of the breaches of the Rancheria Act that was the basis for filing this kind of lawsuit.
Sorry, I don't have to do the operating. Item 47 is the book in the story for which one of the article when she says, Mrs. Bidwell executed a deed to the land upon which the building stood. She requested during court of own mission and then recorded at her death. In a will, she added a 14-acre tract. I don't know if that's the one you're referring to. That's what George Street. She added a 14-acre tract to the mission order and down in trust, with the intention of always seeing the income from that, because then I'm income from of which was supposed to go to maintaining the in Rancheria property. Paid up taxes and everything else. But in another article that I have that the Indian Board of Vision wanted at some point to take that responsibility because they were not in the business of land management or something. That was not their forte. And so sometimes that was broken down.
Well,
So that land was left to them in trust, to the board of commission. Not to the Indians nor to the Secretary of
I'd like to copy that. Well, that raises an issue that, I'm just unterminating the rancheria, but I do want to make it clear that when we filed this lawsuit, we also filed claims for money damages, very broad claims that asserted money damages on behalf of the Indian people for the damages incurred by them as a result of termination. The reason that we agreed to waive money damages, as we haven't done that in every rancheria case. So we did it in the Hardwood case, and we final settlement yet, that's part of the settlement agreement, is that there's still a potential statute of limitations problem in this case. We got over that initial hump prior to trial, but if we go to trial in this case, the government is going to argue that we're too late in filing this lawsuit, which is a risk. There's a risk of going to trial on the damages issue and maybe having them barred by the statute of limitations. The other problem with going forward with the damages claims is, first of all, they'd be very difficult to document, to track exactly what the damages are of each individual person, but not impossible, but difficult. And it will, if we go that route, it'll probably slow this process down considerably. In other words, it would mean saying, no, we're not going to settle. We're going to go to trial on the damages claims. The government would probably, I'm not sure, but I think that they would probably then fight the untermination itself. I've worked on this case. I don't think they would win that part of it, but it would certainly delay us for probably a couple more years in the trial court at least. So there were some decisions made by the people that were participating in the discussions early in this case, and we did try to pull in as many people as possible, that they felt that it was better to try and settle these cases as quickly as possible on what we thought would be terms, waive the money damages. We're waiving our attorney's fees in this case, CILS, and try and get the Indian tribes involved in this case in a position where they can start going after federal funds. Now, our settlement, again, is only with the federal defendants. It's not with the city. It's not with the counties. It's not with third parties. So if there are other claims out there, which we haven't looked at, that you may have, they're not foreclosed by someone in this case.
We can, if we decided to put a suit against, we can do it after we get our rights back and everything we did internally.
Well, yeah, I'm going to say that we have to look at what you're alleging. I mean, I don't know what kind of a claim you have to these lands or anything. I have to look at documents and figure it out. I'm not going to.
I don't mean against the federal government or the city or county, but like the state and other frustrating church.
Well, all I'm saying is I don't have enough information to tell you that you can bring those kinds of lawsuits. All I know is that this lawsuit only settles claims that you have against the federal government. That's all.
What about if we can prove that the college paid bribes to some of the members of the tribe, and we have witnesses? At the time they were
Depends
turning
on
the
when you got that information, because if that information was known to you, or could have been known to you some years ago, you probably...
No, I didn't know until about 10, 15 years ago. The people come up to me and told me. But
May
they
have-
would be
again,
witnesses
you
today
may have-
because it's her father. I
You
mean,
may have some, you're asking some fairly sophisticated legal questions, because...
well, is the college wrong for doing it? I mean, they control it.
They may have been wrong if they did it, and assuming that they did do it, if it was known that they did it 10 or 15 years ago, you're probably barred by the statute of limitations. In
Well,
other words, you can't, that's what happens in a lot of these cases, is you have a good claim. Somebody has done something that has harmed you, and you have a legal claim against them. That if you went to court, you could get relief. But if you don't file the action within a certain period of time, it's gone forever. That's what they call the statute of limitations. Now, under certain circumstances, courts will set aside the statute of limitations. And we alleged in the Scotts Valley case, in this case, that the reason that there is not a statute of limitations bar to the case is because the government lied to the Indians. And that's if we went to trial in this case on all of the issues, including our theory of the case would be that the government lied to the Indians about what they were going to get in the termination process. The Indians never found out that the government lied until approximately 1975. And then there were other intervening events, but in any event, that the statute of limitations did not operate as a bar. So, and the trial court initially said at the outset that it was willing to go to trial on that basis, that it wasn't going to dismiss the Indians' claims based on statute of limitations. But the government would still argue that at trial, if we go to trial. We don't say.
You want to take a break?
Sure.
And
People have.
I have snacks over here if anyone.
I'll totally be here on the
And where you're from, what area?
Chico.
I'm Grover.
I'm Thelma Wilson, daughter of Lenora and Sherman Wilson.
John Ramirez.
What's that, Romero?
I'm Dennis Ramirez. That's Norman's son.
You there too, Jimmy.
Catch him on the wall.
I'm the proud daughter of Vernon and Charlotte Conway. Green Conway, Vernon Conway's daughter.
Louis Wilson, he's the son of Edward Wilson. I'm Frances Wilson, daughter of Edward Wilson.
I'm Charlotte Conway, half of the Conway tribe.
This is my husband Fred. I'm Donna Mae, LaFont Stoke Rickard. My husband Fred, we're from Washington.
I'm Edward Wilson, and I'm the son of Edward Wilson, Effie Wilson, from Chico.
My name's Marcia Simon. I'm from my dad, Carl Delgado. Can you see?
Your name?
I'm Captain Conway from Lakeport. Do I need to come?
I'm David Simmons from Carlton.
I'm Robert Dunn, from the town church.
I'm Juanita Thomas. I'm Carly Conway, daughter of Carl Delgado.
I'm Elaine Wilson Rennick. I'm Francis' daughter.
James Grant. Louis Pete Ramirez. Norman Ramirez.
Pete's also our chairperson. I mean vice chairperson.
Jessica.
Frank Ramirez, I'm Harriet Ramirez Wilson. I'm Sherman Morris.
This is Robert Page.
Yes, I'm taking pictures. Yes, I'm, this is my better half right here. Well, we had a little accident here, I think. Fed driving the car back and forth. He hit this right there in the side of the building. Yes. Now we have first you have the ambulance, the fire department come, and then the ambulance, and there's Joey Lee right there. Now we're trying to get Fred out of the vehicle right at the present time. Donna had just taken and had trouble breathing, She is now put into the ambulance. And there's the ambulance right there. Seems to be doing pretty good. Here comes Fred now. And to the ambulance he goes. I says into the ambulance he goes.
You didn't see my new truck.
I will in a minute there.